And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
A federal court ruling from this past December just did something truly historic. It completely rewrote the rules for gun ownership across the entire United States. And honestly, most gun owners are going about their day with no idea that the legal ground beneath them has shifted so drastically. We are talking about 10 massive structural legal changes that went into effect immediately. These aren't just minor suggestions or small updates. They are powerful protections that defend your rights in ways we haven't seen in over half a century. You need to pay very close attention to every detail here, because law number 10 on this list is an absolute shocker. Just a few weeks ago, regular people were being hauled off to prison for doing the exact same thing that is now federally protected across all 50 states. If you value your freedom and your Second Amendment rights, you'll want to make sure you're subscribed and following these updates closely. Missing even one of these details could be the difference between following the law and facing a serious legal nightmare just because you were operating on old information. This all starts with the first major change, the Supreme Court Protection Standard. This is the big bang of gun rights in America. Everything else we're going to discuss today, every victory and every protection, is built on this new foundation. For over 50 years, the Second Amendment was treated like a second-class right by the courts, but the highest court in the land has just mandated a brand new protection standard. From this moment forward, your right to keep and bear arms receives the exact same maximum legal protection as your right to free speech or your right to practice your religion. Why is this such a game changer? Because before this ruling, politicians could pass almost any restrictive law they wanted. And as long as they could convince a judge it was reasonable for public safety, the law would stand. Those days are officially over. Now, the burden of proof has flipped completely. You no longer have to justify why you need a firearm. Instead, the government must prove with overwhelming evidence why they should be allowed to stop you from having one. They must meet the highest legal hurdle in our justice system, known as strict scrutiny. They have to prove that a law is absolutely necessary for a compelling state interest, and they must prove that the law is the least restrictive means possible. If there is a way to achieve safety without infringing on your right, the government must choose that way. Legal experts are already predicting that over 500 existing federal regulations are headed for the trash bin because they simply cannot survive this new, brutal legal test. The second massive change involves personal police accountability. For decades, there has been a massive wall between citizens and justice called qualified immunity. This legal shield basically meant that if a police officer violated your constitutional rights, maybe by arresting you for a legal firearm or seizing your property without any real cause, you couldn't really do anything about it. The officer was protected, and the department would just brush it off as a mistake. Not anymore. This December decision has sent a clear message to every precinct in the country. If you trample on a citizen's Second Amendment rights, you are on your own. Officers now face personal liability. This means they can be sued in civil court and be forced to pay damages out of their own bank accounts, their own savings, and even their own home equity. We are already seeing the fallout from this change. In Arizona, 2 officers were recently ordered to personally pay $9 million for detaining a woman who was legally carrying with a valid permit. In Georgia, a veteran officer not only lost his entire retirement pension, but is now facing federal criminal charges for an illegal vehicle search and seizure of firearms. Police chiefs and sheriffs across the nation are now issuing emergency memos to their staff. If you mess with someone's gun rights without an ironclad legal reason, the department will not save you from financial ruin. Moving to the third change, we have the total end of red flag confiscations. This is perhaps the most immediate relief for thousands of Americans. Red flag laws were designed to allow the government to seize firearms based on mere allegations, often without the owner even knowing a hearing was taking place. A disgruntled neighbor or a bitter ex-partner could make a single phone call, and by that afternoon, your front door was being kicked in and your property taken. You would then spend months and thousands of dollars in legal fees, trying to prove you weren't a threat just to get your own guns back. The court has now struck this down as a violation of the 14th Amendment's Due Process Clause. The new rule is simple. No arrest, no charges, no seizure. Police cannot take your firearms based on a hunch or a third-party complaint. To take your property, they must now follow the full path of criminal justice. There must be an actual crime charged, and you must have the right to a fair trial before a jury before your property is permanently taken. Anyone who has had their firearms seized under these questionable methods in the last 5 years now has a clear legal path to demand their immediate return. The fourth major shift is the order for deleting the National Gun Database. Despite federal law explicitly prohibiting the creation of a national gun registry, the ATF had been caught building one anyway. They had successfully digitized over 1 billion records. Your name, your address, and the serial numbers of every gun you've ever bought from a dealer, all into a searchable, lightning-fast database. The court has now ordered a digital scorched earth policy. The federal government has exactly 90 days from the ruling to prove that every single one of those digital records has been permanently and irretrievably deleted. This isn't just a request, it's a direct court order. If the ATF fails to provide certified proof of destruction, the specific officials in charge will be held in contempt of court and could face federal prison time. Furthermore, the FBI's background check system has been ordered to stop warehousing data. Once a check is approved, the record must be purged immediately. Fifth, we have new protections for privacy from digital surveillance. We've learned recently that federal agencies were using geofence warrants and credit card tracking to monitor gun owners. They were literally watching who walked into a gun store using cell phone towers and tracking who bought ammo online through bank records. The court has now ruled that exercising a constitutional right is not a suspicious activity. Government agencies are now strictly prohibited from spying on gun owners without a specific individual warrant signed by a judge. This warrant must show probable cause of an actual crime. Not just that you bought a lot of ammunition or searched for certain parts on the internet. That entire surveillance apparatus has been dismantled, and over 60,000 gun owners who were being monitored are now eligible for settlements that are averaging $50,000 per person. The sixth change is the 30-day permit mandate. In states like New York and New Jersey, officials were using what we call the slow walk to deny people their rights. They would take 12 months or even 2 years just to process a simple carry permit. The new federal standard has put a stop to these endless delays. Every state in the union now has a mandatory 30-day deadline. If they don't process your application in 30 days, it is now considered automatically approved by operation of law. Additionally, they can no longer charge you $300 or $400 in processing fees. The court capped application fees at $50 to ensure that the Second Amendment isn't just for the wealthy. Seventh, the courts have ruled that ammunition is a protected product. For years, anti-gun states tried to end run the Second Amendment by attacking the ammo. They required background checks for every box of shells, they banned online sales, and they blocked home delivery. The court has corrected this, stating the obvious: a firearm without ammunition is just a useless piece of metal. Therefore, ammunition receives the exact same constitutional protection as the firearm itself. All state bans on online ammunition sales and home delivery have been declared unconstitutional. You can now order ammo from any website and have it shipped to your door in all 50 states, and the government is prohibited from keeping lists of how much you buy. Eighth on our list is the federal protection for gun dealers. The ATF's zero-tolerance policy was designed to shut down gun shops over the smallest clerical errors. If a dealer wrote St. Dar instead of street, or if a customer's handwriting was slightly messy, the ATF would revoke their license and destroy their livelihood. The new ruling creates a safe harbor for dealers. Paperwork errors are no longer grounds for revocation. Unless the ATF can prove a willful criminal violation of the law, they cannot take a dealer's license. This has already led to a massive resurgence in home-based gun businesses, as people are no longer terrified of being ruined by a simple typo. The ninth change is the end of surprise warrantless inspections. Now, one of the most intimidating tactics used by federal agents was the surprise home visit for collectors or home-based dealers. They would show up at dinner time, demand to see your safe, and threaten you with jail if you didn't let them in right then and there. The court has reinforced the Fourth Amendment. Your home is your castle. Owning a firearm or having a business license does not mean you sign away your right to be free from unreasonable searches. From now on, if an agent wants to see your collection or your paperwork, they need a warrant or a scheduled appointment that you have agreed to. If they show up without a warrant, you have every legal right to tell them to leave your property. Finally, we reach law number 10, the federal shield for interstate travel. This is the big one that affects millions of people. For years, traveling with a firearm felt like navigating a minefield. If you lived in a free state but had to drive through Maryland or New Jersey to get to another free state, you risked being arrested and sentenced to years in prison if you were pulled over with a gun in your trunk. The court has established a federal interstate shield. As long as your firearm is legal where you start your trip and legal where you end it, you have absolute immunity while traveling through any state in between. You are allowed to stop for gas, eat at restaurants, and stay in hotels overnight without creating any legal problems for yourself. If a police officer pulls you over while you're traveling, the key phrase you need to remember is, "I'm traveling under federal interstate protection laws." Knowledge is your strongest defense when it comes to protecting your rights. Your constitutional protections just got significantly stronger, but they only work when you understand them and use them properly. Share this with every gun owner you know and stay updated by hitting that notification bell. Your freedom depends on it. I'll see you in the next one.